Well, I don't even know what to say actually. Technically, good morning. So it's 5 to 2 here in the UK. I was just about to go to bed, but this has dropped, so I have decided to quickly do something on it. Ryan Reynolds and Blake Lively have decided to file a letter seeking leave to supplement their Rule 11 sanctions. I'm just going to read it. The exhibits are sealed, but I have an idea. Like, one of the exhibits is Steve Sarowitz's deposition transcript, and I have a feeling I know which part as well because I did a video on it, which I only uploaded about half an hour ago. So I'll talk about that once I've got through this letter. Plaintiff Blake Lively and former defendant Ryan Reynolds, the Lively parties, respectfully move for leave to file this letter to bring to the court's attention supplemental authority in support of the Lively parties' respective pending motions for sanctions pursuant to Federal Rule of Civil Procedure 11. So this sanctions motion is based on Friedman's statements. And it's one that was filed by both Blake Lively and Ryan Reynolds before Ryan Reynolds was dismissed. It's hard to catch up with all of the, keep up with all the sanctions motions. Since the Rule 11 motions were filed in May, fact discovery has further confirmed that the Rule 11 plaintiffs, the Rule 11 plaintiffs, through Plaintiffs' Counsel, asserted in their amended complaint certain claims against the Lively parties that were frivolous, legally unreasonable, factually without foundation, and brought for an improper purpose. In the deposition of defendant Steve Sarowitz, for example, Mr. Sarowitz admitted that it's redacted, but I do remember Sarowitz. I'm just gonna see if I can go find it. Okay, so I'm just going to. I have found it now. The part I recall, and this is just my thoughts. I don't know. This is what is what is the included excerpt regarding. But there's this question here. So this is on page, it's page 22 of the actual filing, but it's deposition page 177. As you sit here today, this is Gottlieb asking the question. As you sit here today, what is your understanding of the factual basis for intentional and negligent interference with prospective economic advantage against, for example, let's start with Mr. Reynolds. And Sarowitz's response is, and the reason I'm hesitating is I'm not sure where Wayfarer ends and I start. I don't know why the lawyers sued the way they did. I'm not a lawyer, so I'm not really an expert on the law. So I wonder if that has something to do with it. So I wonder if this first redacted part at the top is saying basically Mr. Sarowitz admitted that he did not know why the lawyers sued the way they did. Shocking as these admissions were, given that Mr. Sarowitz personally brought claims for civil extortion, defamation, and tortious interference with contract against the Lively parties, Mr. Sarowitz further testified that, redacted. Defendant Jennifer Abel similarly testified that, redacted. Her testimony illustrates precisely why sanctions against plaintiff's counsel are appropriate. Plaintiff's counsel knew there was no conceivable factual basis to assert the challenged claims, and that their clients could not articulate any, and nevertheless brought the claims in an effort to harass the Lively parties, create delay, and increase costs of litigation. The lively parties respectfully request that the court consider this additional evidence when imposing appropriate sanctions in light of the substantial Rule 11 violations set forth in the motions. I mean, the depositions were done over a month ago. This has been timed to get out get ahead of some of the PR and the bad press that she's getting from, the motion for summary judgment and all the attachments. Okay. So that was the letter. This is the actual supplement that they want to add. So background. On May 19th, 2025, Ms. Lively filed her Rule 11 motion. That motion outlined in detail how the Rule 11 plaintiffs each brought multiple claims against Ms. Lively in the first amended complaint, absent any legal or factual basis. Specifically, Ms. Lively demonstrated that 1. Mr. Sarrett, Ms. Nathan, Ms. Abel, and It Ends With Us each sued Ms. Lively for extortion, despite the first amended complaint containing no facts that Ms. Lively made any extortionate threats against any of them or deprived them of anything at all as a result. 2. Mr. Sarrett, Ms. Nathan, Ms. Abel, Mr. Heath, and It Ends With Us each sued Ms. Lively for interference with a contract and prospective economic advantage in relation to a talent agency with which they had no contractual or economic relationship at all. And 3. Mr. Heath, Mr. Sarrett, Ms. Nathan, and Ms. Abel each sued Ms. Lively for breach of the covenant of good faith and fair dealing without any allegations in the first amended complaint that any of them were parties to the ACTA agreement the claim was based on. Ms. Lively further demonstrated that plaintiff's counsel repeated public attacks on her illustrate that the Rule 11 plaintiff's frivolous claims were brought for the improper purpose of harassing Ms. Lively, causing delay and increasing the cost of litigation. On May 20th, 2025, Mr. Reynolds filed his Rule 11 motion, similarly asserting that the Rule 11 plaintiffs' extortion claims and interference claims were legally unreasonable and factually baseless. In addition, Mr. Reynolds explained how the Rule 11 plaintiffs' defamation claims against him were also sanctionable, as not one of the Rule 11 plaintiffs could identify a single defamatory statement that he made concerning them. In their 11-page opposition to these Rule 11 motions, the Rule 11 plaintiffs and their counsel did not dispute that their allegations were legally and factually baseless. Instead, their only arguments against the imposition of sanctions were that Rule 11 sanctions were unavailable to address pleadings that could be subject to a Rule 12 motion to dismiss, and that out-of-court statements could not be considered to establish an improper purpose. At his deposition, Mr. Sarrett was redacted. When asked whether he had any factual basis for his extortion claim, Mr. Sarrett redacted. He also could not, redacted. And when asked about redacted, Mr. Sarrett redacted. Mr. Sarrett's testimony leaves no doubt that his claims, like those of the other Rule 11 plaintiffs, were brought without any cognizable factual basis. The same is true for Ms. Abel, who could not, redacted. Of course, had such events actually occurred, Ms. Abel would not have had to learn about them for the first time from her attorneys. Ms. Abel, redacted. The inescapable conclusion is that the Rule 11 plaintiffs' counsel manufactured the challenged claims in an effort to harass the lively parties, create undue burden, and increase the costs of the litigation. For these reasons, and those set forth in the lively parties' Rule 11 motions, the court should impose sanctions on the Rule 11 plaintiffs and plaintiffs' counsel pursuant to Rule 11. Signed, Gottlieb. All right. Yeah, I'll leave it there. Could I ask you, please, really sweetly, if everyone could just take a moment to like the video, subscribe to the channel, press the notification bell, and if the option to hype is available, it would greatly help my channel. I have already put out the part 1 and part 2 to the read through of the deposition transcript, so they are quite long because there's a lot to go through. But they are also quite spicy. There's quite a bit of tea in them, so well worth the watch. Okay, I'm now going to go to bed. Thanks for watching. Good night.